Imagine this. A corporate client calls your office in a panic. We just discovered that one of our suppliers is on an international sanctions list. What should we do? You open the compliance file. The company operates under a strict regulatory framework with reporting duties, anti money laundering rules, and data protection requirements. If they failed to act, the breach could trigger serious penalties or even a criminal investigation. Your role as a lawyer isn't just to cite the law, it's to explain the process clearly, professionally, and calmly. You must say things like, the matter is currently subject to investigation, and all actions will be taken in accordance with regulatory requirements. In this lesson, you'll learn how to advise clients on compliance issues using precise legal English. You'll practice the vocabulary lawyers use in corporate compliance reports, the passive structures that emphasize procedures over people, and the conditional sentences that describe legal consequences clearly. For example, if the audit trail is incomplete, the company may face sanctions. By the end, you'll sound like a compliance professional, diplomatic, accurate, and confident under pressure. In this lesson, you'll learn how to communicate like a compliance lawyer, someone who advises clients when rules are broken, investigations begin, or policies must be improved. First, you'll build your vocabulary for compliance. Terms like regulatory framework, breach of compliance, audit trail, and the risk assessment that lawyers use when describing obligations and internal controls. Then, you'll focus on grammar that supports precision and professionalism. You'll practice the passive voice to keep the focus on procedures, not people. For example, the report was submitted to the authorities. You'll also use conditional sentences to predict legal outcomes and advise clients diplomatically. For example, if the company fails to report the breach, it may face financial penalties. Finally, you'll apply these skills with key compliance expressions in accordance with regulatory requirements and subject to investigation to sound accurate and authoritative in both writing and speech. By the end, you'll be able to explain compliance risks, describe internal investigations, and provide clear formal advice that clients and regulators trust. Let's begin with a real-world scenario. A logistics company from Chile has just expanded operations into Florida. During an internal audit, the compliance officer discovers that one of their subcontractors appears on a U.S. sanctions list. No one intentionally violated the law, but the transaction record is incomplete, and there's no proper audit trail to prove what happened. The company's general manager is anxious. Are we in trouble? Will we be fined? This is where your role as a lawyer becomes critical. You must explain the situation calmly and in professional legal English. The transaction is currently subject to investigation, but all corrective actions will be taken in accordance with regulatory requirements. You'll also prepare a short memo advising next steps, suspend payments, gather documents, and conduct a risk assessment. You use passive forms. The report will be submitted. The records are being reviewed to keep the focus on the actions, not to blame. Finally, you clarify possible outcomes using conditionals. If the company cooperates fully, the regulator is unlikely to impose sanctions. This story reflects real compliance lawyering, balancing urgency, precision, and reassurance when guiding clients through high-stress investigations. The regulatory framework is the foundation of every compliance system. It refers to the network of laws, government regulations, and administrative guidelines that control how a business must operate. For instance, banks, energy companies, and technology firms all work under different frameworks, from anti-money laundering laws to data privacy and environmental standards. In the example sentence, A financial institution is required to follow both local and international regulations. For a bank in Mexico or Colombia, that might mean complying with local central bank rules and U.S. laws like the Foreign Corrupt Practices Act. When advising clients, lawyers often explain which regulatory frameworks apply, where there are overlaps, and what must be reported to stay compliant. They use passive construction, such as the company is regulated by the National Securities Commission, to focus on the system, not the actor. Understanding a regulatory framework allows you to identify risk areas before violations occur, a crucial step in proactive compliance advice. A breach of compliance occurs whenever a company or individual fails to meet legal or regulatory obligations, whether intentionally or accidentally. This could include missing a reporting deadline, hiding a transaction, or failing to perform due diligence. In the example, the audit uncovered that financial transactions weren't properly recorded. Even if no fraud occurred, the omission itself constitutes a breach of compliance because it violates internal record keeping rules and possibly external financial regulations. Lawyers use this term frequently in compliance reports and investigations. You'll often hear a potential breach of compliance was identified and reported to the regulator. Notice the passive structure. It keeps the focus on the process, not on assigning blame. When advising clients, lawyers must also explain consequences using conditionals. If the breach is not corrected, the company may face administrative penalties. Understanding this phrase helps you describe noncompliance objectively, a skill crucial when investigating internal issues or communicating findings to regulators. A due diligence procedure is one of the first lines of defense in corporate compliance. It is a structured investigation designed to confirm that a business partner, supplier, or transaction complies with all relevant laws. In the example, the company reviews new suppliers' ownership structures and checks them against sanctions lists, ensuring no partner is linked to illegal or restricted activity. This process helps prevent corruption, money laundering, or reputational harm. Lawyers and compliance officers document every step: background checks, financial reviews, and interview notes. The goal is to create a verifiable record and audit trail, proving that the company took reasonable measures before signing an agreement. In written reports, passive constructions are typical. The supplier was screened for potential sanctions risk, or all documents were verified prior to approval. When you advise a client, emphasize that due diligence isn't just a box ticking exercise, it's evidence of good faith. And if done properly, it can protect the company if regulators later question a transaction. An audit trail is the digital or paper record that proves what actions were taken, by whom, and when. In compliance, it's the evidence that a company has acted transparently and within the rules. In the example, regulators asked for the company's audit trail to verify that payments have been properly authorized and recorded. This helps ensure that no one manipulated or deleted transactions after the fact. Audit trails are essential during investigations or audits. They allow both internal and external reviewers to reconstruct events and confirm accountability. In compliance language, you will often hear passive statements like, all entries were logged automatically, or the records were archived for regulatory review. A missing or incomplete audit trail can raise red flags, suggesting poor internal controls or a potential breach of compliance. That's why lawyers advise clients to maintain accurate, traceable records, not only for legal protection, but also to demonstrate corporate integrity when questions arise. A sanctions list is one of the most critical tools in compliance. Governments and international organizations such as the U.S. Treasury's OFAC, or the United Nations, or the European Union, they publish these lists to restrict trade and financial transactions with certain individuals, companies, or countries. In the example, the compliance team checks every new client against an international sanctions list before opening an account. This step helps prevent violations of anti money laundering or counterterrorism laws. Even an unintentional transaction with a sanctioned party can result in heavy fines or reputational damage. Lawyers must understand how these lists work and how to document compliance. Passive phrasing is common in reports. All transactions were screened against the applicable sanctions list. For Latin American companies, for example, doing business with US or European partners, sanction screening is a daily routine. Advising clients on how to maintain reliable screening systems and keeping evidence of those checks is an essential part of modern compliance practice. Whistleblower protection is a cornerstone of modern compliance systems. It ensures that employees who report wrongdoing, such as fraud, bribery, or safety violations, are legally protected from retaliation. In the example, the company revised its internal policy to promote transparency and safeguard employees who speak up. This step, it builds trust, and it also helps detect issues before they escalate into full legal crises. In the United States, laws like the Sarbanes-Oxley Act and the Dodd-Frank Act provide strong whistleblower protections. Many countries around the world have adopted similar frameworks, often requiring companies to create anonymous reporting channels. In legal writing, you'll often read, "Reports submitted under the whistleblower policy shall remain confidential." The passive form emphasizes process and confidentiality rather than individuals. When advising clients, lawyers must explain both the legal duty and the cultural importance of protecting whistleblowers. A strong whistleblower policy not only reduces legal exposure, but also shows regulators that the company promotes integrity and accountability at every level. A risk assessment is the backbone of every effective compliance program. It's a structured review used to detect where a company might face legal or regulatory problems before they occur. In the example, the compliance department analyzes vulnerabilities related to data protection and financial integrity. This proactive approach allows management to prioritize actions, strengthen internal controls, and allocate resources effectively. Risk assessments often include interviews, policy reviews, and document analysis. The process is formal and carefully documented. Every observation must be traceable, forming part of the audit trail. Reports typically use the passive voice. High-risk transactions were identified, or policies were reviewed for potential weaknesses. Lawyers and compliance officers use these reports to brief clients or boards of directors. A well-written risk assessment combines factual precision with professional tone. It avoids blame and focuses on solutions. Advising clients to conduct regular risk assessments demonstrates diligence, foresight, and of course, a genuine commitment to compliance culture, values that international regulators increasingly expect. In compliance and regulatory writing, lawyers often use the passive voice to make their tone objective and formal. Instead of focusing on who did something, we focus on what was done, the process itself. For example, the report was submitted to the regulator emphasizes the completed action, not the author. Similarly, all records are reviewed before approval, highlights procedure, not personnel. This tone is vital in compliance contexts where the goal is to present facts neutrally. Using passive structures removes personal language that might sound emotional or accusatory, especially during internal investigations or audits. Lawyers frequently write, the transaction was identified as high risk, or the supplier was cleared after verification. Each phrase maintains professionalism and clarity. Passive voice also helps when multiple teams or offices are involved. The due diligence report was prepared jointly by both firms. Remember, in compliance communication, the passive voice doesn't weaken your writing, it strengthens credibility by centering attention on process, procedure, and legal outcome rather than blame. Conditional sentences are powerful tools in legal English because they connect actions with consequences. Exactly what lawyers, specifically compliance lawyers, do every day. The first conditional describes real, possible outcomes in the present or future. For example, if the company fails to report the breach, it may face penalties. This is common in advice or risk reports. It sounds factual, not emotional. The second conditional presents a hypothetical scenario, often used to discuss preventive measures. If the audit were delayed, the regulator would question the company's diligence. It helps clients understand risks that could arise if procedures are not followed. The third conditional looks back to analyze missed opportunities or failures. For example, if the due diligence had been completed earlier, the breach could have been avoided. Lawyers use this structure when reviewing past incidents or drafting internal reports after investigations. In compliance communication, conditionals let you speak with precision and diplomacy, clearly linking legal obligations to their consequences without sounding accusatory. This is how lawyers express cause and effect with professionalism. Let's practice applying conditional sentences to real compliance situations. Each one connects a cause, the action taken or not taken, to a legal consequence. Look at the first example. If the company discloses the incident immediately, the regulator may reduce the fine. This is a first conditional. It refers to a real, possible action. It helps lawyers show that prompt transparency can mitigate, reduce penalties. Now, the second. If the internal audit were postponed, potential breaches might go undetected. The second conditional expresses a hypothetical risk, a warning about what could happen if controls fail. It's ideal for internal memos or client briefings. Third, if proper due diligence had been conducted, the supplier issue could have been avoided. This third conditional looks back at what went wrong. Lawyers use it in post-investigation reports to identify lessons learned. Finally, if employees followed the internal policy, future violations will be prevented. This sentence highlights prevention and shows compliance as an ongoing process. When you advise clients, conditionals let you connect advice, consequence, and responsibility logically, transforming complex risk analysis into clear, actionable English. The phrase in accordance with regulatory requirements is one of the most common and most powerful expressions in compliance communication. It signals full adherence to the laws and standards governing a company's operations. In the example, every financial transaction must follow both external laws, those set by regulators, and internal policies, the company's own rules. This dual layer of compliance is typical in industries like finance, healthcare, and international trade. Lawyers use this phrase frequently in reports, legal opinions, and contractual clauses. It sounds more formal than according to the law and more precise than in line with the rules. For example, all actions were taken in accordance with regulatory requirements. The passive construction emphasizes process and conformity, not personal responsibility, which fits the tone of legal writing. When advising clients, this phrase reinforces credibility. It tells regulators and stakeholders that every step was reviewed, documented, and performed under the correct legal authority. essential language for maintaining trust and demonstrating compliance. The phrase subject to investigation is used when a person, company, or transaction is being formally reviewed by an authority. It does not automatically mean guilt or wrongdoing, only that regulators are examining the facts. In the example, the company's transactions with a supplier have drawn attention from the Financial Intelligence Unit, perhaps because of missing documentation or potential sanctions exposure. Using the phrase subject to investigation keeps the tone neutral and factual, avoiding emotional or accusatory language. Lawyers rely on this phrase in correspondence, press statements, and internal reports to describe ongoing inquiries professionally. It appears often in sentences like, "The matter is currently subject to investigation, and full cooperation has been provided." Notice the passive voice. It focuses on the process, not on who initiated. When advising clients, this expression helps manage risk and perception. It shows that the company acknowledges the situation, is cooperating with authorities, and understands its legal obligations, a key part of responsible compliance communication. A compliance monitoring program is the mechanism that keeps a company compliant day to day. It's not a one-time audit, it's a continuous process of checking whether internal policies and external regulations are being followed. In the example, the company strengthens its system by adding quarterly risk reviews and training sessions. This shows that compliance isn't reactive, it's proactive. The goal is to identify potential problems before they become breaches of compliance. A strong monitoring program usually includes regular internal audits, employee certifications, and automated tracking tools. Lawyers and compliance officers often describe it in reports using the passive voice. Transactions are reviewed under the compliance monitoring program, or policies are updated as part of ongoing compliance monitoring. When you advise corporate clients, recommending such programs demonstrates foresight and accountability. Regulators often ask not just what went wrong, but what systems were in place to prevent it. A well designed compliance monitoring program is the company's best defense and its strongest signal of integrity. A reportable incident is any event that a company is legally required to disclose to authorities, even if it was unintentional or quickly corrected. This term is central to modern compliance frameworks, particularly in areas such as data protection, environmental regulation, and financial reporting. In the example, a data breach triggered a mandatory notification to the National Data Protection Agency within the statutory 72-hour period. The speed and accuracy of that report demonstrate regulatory transparency and good faith, both key principles in compliance law. Lawyers use this phrase in risk assessments, internal memos, and regulatory correspondence. The event was treated as a reportable incident under applicable legislation. The passive construction emphasizes process and compliance rather than fault. For clients, understanding what qualifies as a reportable incident is crucial. Failing to report on time can lead to fines, loss of licenses, or reputational harm. Advising on these obligations and helping clients prepare reporting procedures shows the value of precise, preventive legal English and international compliance practice. Let's end with a story that reflects a real challenge many companies face. A mid-sized manufacturer with operations in Costa Rica, Panama, and Colombia receives an anonymous whistleblower report. The message alleges that one of its regional managers made irregular payments to a government supplier. The board immediately opens an internal investigation. All records are reviewed, but the audit trail for those transactions is incomplete. Because public funds are involved, the case becomes subject to investigation by local authorities. The company's lawyers move fast. They suspend the payments, prepare an internal risk assessment, and notify regulators in accordance with regulatory requirements. Every email and memo is written in a neutral procedural tone. The transactions were reviewed, and all supporting documents were collected for verification. Using passive voice keeps the communication factual and professional. Conditional reasoning helps guide decisions. If full cooperation is maintained, the authority may close the case without penalty. After several weeks, no criminal intent is found, only procedural weakness. The company expands its compliance monitoring program, improves its reporting system, and classifies the case as a reportable incident. This story shows the value of clarity, documentation, and professional tone, the tools every lawyer needs when advising on compliance in the corporate environment. In this lesson, you learned how to communicate like a corporate compliance lawyer, someone who protects companies by ensuring every decision, report, and document meets legal standards. You have mastered specialized vocabulary such as regulatory framework, audit trail, sanctions list, and whistleblower protection, the language of modern compliance teams across Latin America and the US. Grammatically, you practice the passive voice, perfect for formal reports and internal investigations, where the process matters more than the person. You also worked with conditional sentences to show how legal consequences depend on specific actions. If the company fails to report, it may face penalties, for example. We explored key legal expressions like in accordance with regulatory requirements, subject to investigation, compliance monitoring program, and reportable incident. Phrases that add professionalism and precision to every email, memo, or report. Finally, through the compliance investigation story, you saw how clarity, structure, and neutrality help manage sensitive cases. Your main takeaway? Compliance is about more than vocabulary. It's about credibility, accuracy, and tone. When you communicate clearly and objectively, you not only protect your client, but you also strengthen trust in the legal profession.